This is the image they said was months away. A clerk at the New York Supreme Court Appellate Division, First Department, walking briskly down a marble corridor at 8:47 a.m. on a Wednesday morning, carrying a sealed envelope to the filing window. Inside that envelope is a 52-page ruling that was not supposed to exist until April. As of 9 a.m. this morning, Wednesday, February 12, 2026, the appellate court has issued its decision on the Trump civil fraud appeal 6 weeks ahead of the earliest projected timeline. The ruling is devastating. The fraud finding is upheld. The judgment is confirmed at $426 million. And buried on page 38 in a passage that legal analysts are calling unprecedented in modern New York jurisprudence, the panel has added something the defense never anticipated: a sua sponte order for accelerated enforcement, meaning the court, on its own initiative, without a motion from the Attorney General, has directed that the judgment be executed on an expedited basis due to what it calls the defendant's demonstrated pattern of asset concealment and valuation fraud. For the first time in this case, the court is not just ruling against Trump, it is actively accelerating the destruction of his financial position. The timeline that the defense team built their entire strategy around has collapsed. The calendar is gone. The clock is not ticking. It has already struck. We are talking about a ruling that compressed a 90-day expected enforcement window into 14 days. We are talking about a sua sponte enforcement acceleration that sources inside the appellate court say has not been issued in a civil fraud case of this magnitude in at least 3 decades. We are talking about a bonding company, Knight Specialty Insurance, that received the ruling at 9:03 a.m. and, according to sources inside the New York Department of Financial Services, notified the court by 10:15 a.m. that it would not extend its guarantee under the accelerated timeline. We are talking about an immediate cascade of legal deadlines that Trump's already fractured defense team cannot possibly meet. We are talking about the entire legal strategy of delay, which has sustained Donald Trump through decades of litigation, being dismantled in a single morning by 3 appellate judges who decided they had seen enough. In this special report, we are going to break down exactly what this accelerated ruling means. We are going to explain the legal mechanism of sua sponte enforcement and why it is so rare and so lethal. We are going to trace the 14-day countdown that begins today and identify every asset in the crosshairs. And we are going to reveal what sources inside the defense team say happened when the ruling hit their phones at 9:01 a.m. this morning. Buckle up. The courts have moved faster than anyone expected. The strategy of delay is dead, and the reckoning that was supposed to arrive in the spring just landed in the middle of winter. To understand why this ruling is so devastating, you have to understand that delay was not merely a tactic for Trump's legal team. It was the strategy. The entire architecture of the defense, from the initial trial through the appeal and the bonding process, was designed around one principle: stretch the timeline. Every motion to dismiss, every request for extension, every procedural challenge was calibrated to push the enforcement date further into the future. The logic was simple and, until this morning, effective. Time creates optionality. The longer you delay, the more chances you have for a political shift, a favorable Supreme Court ruling, a settlement opportunity, or simply a change in the financial environment that makes refinancing or bonding possible. Sources inside the defense team say the internal projection, as recently as last Friday, was that the appellate ruling would arrive in late March or early April, giving them a minimum of 6 additional weeks to shore up the bonding arrangement, explore refinancing options for the encumbered properties, and prepare the Supreme Court emergency stay application. The accelerated ruling obliterated every assumption. 6 weeks of strategic planning evaporated in 6 minutes. Here is the technical mechanism that makes the accelerated enforcement so lethal, and this is where most of the mainstream coverage has missed the story entirely. A sua sponte order is an action taken by the court on its own initiative without either party requesting it. In standard civil litigation, enforcement timelines are governed by procedural rules and motions filed by the prevailing party. The plaintiff wins, files an enforcement motion, the defendant responds, the court schedules a hearing, and the process unfolds over weeks or months. What the appellate panel did this morning bypasses that entire structure by issuing the enforcement acceleration as part of the ruling itself, embedded in the appellate decision rather than as a separate post-judgment proceeding. The court eliminated the defendant's procedural opportunity to contest the timeline. There is no motion to oppose. There is no hearing to request. The 14-day window is not a proposal. It is an order. It is an Trump's attorneys can file an emergency motion to stay the accelerated timeline, but they would be asking the very court that just imposed it to reverse its own decision, which, as any appellate litigator will tell you, has a success rate that approaches zero. The only remaining avenue is the Supreme Court, and the application process for an emergency stay at the federal level requires a showing of irreparable harm and a likelihood of success on the merits. Given that the appellate court just issued a 52-page opinion explaining in granular detail why the fraud finding is supported by the evidence, demonstrating a likelihood of success on the merits is, to use the clinical term, a fantasy. The court's reasoning for the acceleration is laid out in pages 38 through 44 of the opinion, and it is a masterclass in judicial demolition. The panel cited three specific grounds. First, what it called the defendant's demonstrated history of asset manipulation. The court noted that since the original trial, the independent monitor, retired federal judge Barbara Jones, has filed 6 quarterly reports identifying continuing irregularities in the Trump Organization's financial representations. The panel cited a specific instance from the monitor's October 2025 report in which the organization reported the value of a commercial property at $220 million to a prospective lender, while simultaneously reporting the same property at $148 million to insurance underwriters. The court called this dual valuation practice evidence that the fraudulent conduct at the heart of this case is not historical, but ongoing. Second, the court cited what it termed flight risk of assets. The panel noted that since the original judgment, the Trump Organization has restructured several holding companies, transferred management responsibilities between affiliated entities, and renegotiated licensing agreements in ways that, in the court's view, had the effect of shielding revenue streams from potential enforcement. The court stopped short of calling it asset concealment, but the implication was unmistakable. Third, and most devastating, the court cited the global financial environment. The panel noted that the ongoing instability in international bond markets, referencing the Japan's sovereign debt crisis specifically, has created conditions in which the value of the defendant's real estate assets is declining on a weekly basis. Delayed enforcement, the court concluded, would result in the progressive erosion of the judgment's recoverability. In plain language, every day we wait, the buildings are worth less and the chance of collecting the full judgment shrinks. So we are not waiting. At 10:15 a.m. this morning, Knight Specialty Insurance formally notified the court that it would not extend its bond under the accelerated enforcement timeline. This was the final structural failure. The bond, which had been the single barrier between the judgment and Trump's assets, is now void. Sources inside the Department of Financial Services say Knight Specialty's decision was not discretionary. The DFS had been conducting a quiet examination of Knight's reserves since October 2025 and had already flagged the company's surplus as potentially insufficient to cover the $426 million obligation. The accelerated timeline simply made the mathematics impossible. Knight would have needed to maintain liquidity reserves against the full judgment amount for only 14 days. But the reputational and regulatory risk of being the company that backed a bond that was about to be enforced was, in the words of one industry source, career-ending for every executive on the board. They pulled the plug in 72 minutes. The speed tells you everything about how the insurance industry now views Trump exposure. It is not a calculated risk. It is a contagion they want no part of. Now, let me walk you through the 14-day countdown because every day has a specific legal and financial event attached to it, and the cumulative effect is a controlled demolition of the Trump Organization's operating capacity. Day 1, today, February 12th. The ruling is published, the bond is voided, and the Attorney General's office files the enforcement motion. Sources inside the AG's office say the motion was pre-drafted weeks ago, waiting for exactly this scenario. Day 3, February 14th. Justice Engoron is expected to sign the enforcement order, authorizing receivership of 40 Wall Street, receivership of Trump Towers commercial operations, forced listing of 7 Springs, and a blanket bank levy across all Trump Organization accounts in New York State. Day 7, February 19th. The receiver takes physical possession of 40 Wall Street. Locks are changed. The Trump Organization management team is relieved of authority. All tenant rental payments, approximately $14.2 million per quarter, are redirected to the Attorney General's escrow account. Day 10, February 22nd, the bank levy executes. Sources estimate that approximately $62 million in liquid deposits will be captured across accounts at JP Morgan Chase, Axos Bank, and Deutsche Bank's successor entity. Day 14, February 26th. The enforcement window closes. Any assets not seized or placed under receivership by this date may require a new motion. But by this point, the core revenue-generating properties and liquid accounts will already be under state control. This is where the crisis escalates from legal enforcement to constitutional confrontation. Trump Tower is not merely a commercial property under receivership. It is the private residence of the President of the United States. The Secret Service maintains a permanent security perimeter. When the receiver arrives on day 7 to take control of the commercial floors, the receiver carries a court order. The Secret Service agent at the elevator carries a federal security directive. Sources inside the protective detail say they have received no guidance from the White House or the Department of Homeland Security on how to handle the competing authorities. One agent speaking through an intermediary described the situation as two legal universes colliding in the same lobby. The Attorney General's office has anticipated this. They are targeting the commercial entities, the LLCs that own the retail space, the management contracts, the bank accounts. You do not need to enter the penthouse to seize the corporation that controls the penthouse. But the visual state officers taping enforcement notices to the windows of the president's home while Secret Service agents watch from 10 feet away is a humiliation designed to be broadcast, and it will provoke a reaction. Sources inside the West Wing describe the president's response to this morning's ruling as beyond anything staff have witnessed in 2 years of crisis management. He was briefed on the accelerated ruling at 9:04 a.m. by his deputy chief of staff for operations because his lead personal attorney, Alina Habba, had already filed a motion to withdraw from representation 2 days earlier and was unreachable. The president reportedly demanded an immediate conference call with every attorney who has ever represented him in any matter. Sources say the call was assembled by 10:30 a.m. and included attorneys from 4 different firms, none of whom are currently retained as counsel of record in the civil fraud case. The president's instructions, according to 2 participants on the call, were to find any mechanism, executive, legislative, or military, to prevent the enforcement order from being signed on Friday. One participant described the call as a man asking his doctors to reverse the laws of physics. Another said he kept saying the word impossible, not about the legal situation, about the concept that this could be happening to him. But here is what nobody is talking about. The accelerated timeline does not just affect the civil fraud case. It triggers cross-default provisions across the entire debt structure on a compressed schedule that the lenders themselves are not prepared for. Ladder Capital's $138 million mortgage on 40 Wall Street contains a covenant that requires the borrower to maintain unencumbered control of the property. The moment a receiver is appointed, that covenant is breached. Ladder's credit committee must then decide within 5 business days whether to declare a formal default and accelerate the loan. Under the original timeline, that decision would have played out over weeks, with informal discussions, forbearance negotiations, and standstill agreements. Under the 14-day timeline, Ladder has to make a $138 million decision in less than a week. Sources inside Ladder Capital say the board is leaning toward acceleration because the alternative, sitting on a non-performing loan secured by a property under state receivership with a declining commercial real estate market and a politically toxic borrower, is worse. If Ladder accelerates, the cross-default clause in the Axos Bank mortgage on Trump National Doral, approximately $125 million, triggers automatically. The cascade then reaches the Trump International Hotel in Washington at $170 million and the Chicago Tower at roughly $100 million. Total potential accelerated debt, $1.2 billion. The compressed court timeline has compressed the financial timeline. The dominoes are falling in days instead of months. How does this play with the political base? The acceleration has created a narrative split that is deepening by the hour. The grassroots MAGA base sees judicial overreach. They see an activist appellate panel fast-tracking enforcement to humiliate a Republican president before he can mount a defense. The phrase kangaroo court is trending on Truth Social. Expect the fundraising emails to spike. Expect protests outside the courthouse. But the institutional Republican money sees something different. They see a court that issued a 52-page, meticulously reasoned opinion with specific citations to ongoing fraud documented by the Independent Monitor. The donor class reads legal filings. They understand that sua sponte acceleration does not happen without overwhelming justification. One major donor, speaking to the Wall Street Journal on background, said the accelerated timeline actually made us more comfortable with our decision to pull support because it confirmed that the legal exposure is worse than we thought, not better. Major donor commitments for the 2026 cycle have now declined by 51%. The financial base of the Republican Party is in open revolt against its own president. What does the world see? It sees an American judiciary moving at a speed and with a decisiveness that contradicts every international narrative about American legal paralysis. Putin, who built his domestic propaganda around the idea that Western legal systems are tools of political persecution rather than instruments of accountability, is watching a court system that documented its reasoning across 52 pages and accelerated enforcement based on specific cited evidence of ongoing misconduct. That is not persecution. That is precision. Xi Jinping, who has spent years arguing that American democracy is too slow and too divided to compete with Chinese state efficiency, is watching the opposite. A state appellate court making a decisive, rapid, institutionally grounded decision. European allies, still reeling from the Greenland diplomatic fiasco, see a judiciary that functions even when the presidency does not. The international signal is complex but unmistakable. The American system is stressed, but the courts still work. History teaches us that the critical variable in constitutional crises is not the severity of the offense, but the speed of the institutional response. Watergate took 26 months from break-in to resignation. The Andrew Johnson impeachment took 11 months from the triggering event to acquittal. The Clinton impeachment stretched across a full year. This crisis is operating on a 14-day timeline imposed by the judiciary itself. The compressed tempo changes the political physics. There is no time for public opinion to settle. There is no time for congressional hearings to build a narrative. There is no time for the White House to construct a counter-strategy. The court has, intentionally or not, created a constitutional pressure cooker in which every institution, the presidency, the Congress, the Supreme Court, the lenders, the markets, must react simultaneously rather than sequentially. The founders designed a system of deliberative governance. Deliberation requires time. The court just eliminated the time. This is not just a legal proceeding. This is the stress test of whether American institutions can absorb the simultaneous compression of a financial crisis, a constitutional confrontation, and a political realignment, all operating on a 2-week clock imposed by 3 appellate judges who decided that delay itself was a form of injustice. We are in territory that has no precedent. The constitutional maps were drawn for a world that moved at the speed of deliberation. This crisis is moving at the speed of enforcement. And the man at the center of it, stripped of his lead counsel, stripped of his bond, stripped of his timeline, has 14 days to find a legal theory, a financial instrument, or a constitutional mechanism that can stop a machinery that 3 courts and an independent monitor have unanimously concluded he built on fraud. Here's what you need to watch. Watch Justice Engoron's calendar on Friday. If he signs the enforcement order on day 3 as projected, the physical seizure process begins immediately. Watch Knight Specialty's stock and credit rating. If Moody's downgrades the company by end of week, the insurance industry's Trump exposure becomes a systemic story. Watch the Supreme Court emergency docket. Trump's team must file within 48 hours to have any chance of a stay before the receiver takes possession of 40 Wall Street on day 7. Watch Ladder Capital's next 8K filing with the SEC. If they disclose a material impairment on the Trump loan, the stock drops and the cross-default cascade accelerates. Watch the congressional calendar. 3 Republican senators have privately indicated willingness to call for an independent investigation if the enforcement proceeds without Supreme Court intervention. The first public statement breaks the dam. The clock started at 9 a.m. this morning. 14 days. That is what separates Donald Trump from the full liquidation of his New York empire. 14 days in which the courts, the lenders, the markets, and the Constitution itself will be tested at a speed that none of them were designed to handle. The strategy of delay, the only strategy that ever truly worked for this defendant, is dead. The calendar killed it. And the man who spent 40 years outrunning the clock just discovered that the clock learned to run faster. Subscribe. Stay locked in. Day one is already over. 13 remain, and every single one of them will be worse than the last. The history books are being written in real time, and the ink is not drying fast enough to keep up with the next chapter.